Record in 231-500-139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present as well. Mr. Burmester, anything on the record before we invite the jury in?
Your Honor, the state's first witness is Dr. Eric Christensen. I was notified by counsel this morning that they intend to move to exclude or suppress his testimony, and I will let them make whatever motion they want to make.
Counsel, tell me more.
Judge, it is simply that we have not been able to consult with Dr. Christensen. We have reached out to him we have not been able to consult with Mr. Christensen or Dr. Christensen. We've reached out numerous times, got on the phone with him once. He was unavailable, asked if we could get some time with him. That was about 4 or 5 weeks ago, and haven't heard anything. Last week, we informed the state that we haven't been able to get in touch with him, asked the state to have him reach out to us. He has not reached out to us, so just based on just the rule, and he should be available to cooperatively consult with us. He did not.
I appreciate that. He's here now.
I understand. I think
Mr. Burmester, if we flip the order of events, can we allow Dr. Christensen to consult with defense counsel since he's physically present, and then we can use the time for a different witness?
I have no objection to that. Indeed, I asked counsel if time we 15 minutes ago, that was enough time. That's not. So,
Who else do you have on deck?
I don't know.
Your Honor, let me see. I don't know if we have anybody in until 9, but we'll see.
Okay.
Your Honor, we have an objection to another witness that the state intends to call today.
Let's do it all.
Okay, but let's stay focused on this one for the moment. Mr. Ramos, make a record for me. If I change the order of witnesses and just order Dr. Christensen to consult with you since he's physically present, anything further on that?
just assuming that we can take that break. I'm not sure who's next and whether it's my witness or not.
Understood. Okay.
Absent that, I will make do. Obviously, I didn't want to do that rushed before we got here. So if we can have an hour or whatever we need,
Right.
that'd be great.
Let's figure out what the order of witnesses is going to
Thank you,
be.
May I just have the benefit of the record for
Sure.
like 1 minute? So I spoke to Mr. Christensen or Dr. Christensen this morning. He says that he received a call several months ago from Mr. Bertram saying, hey, we need to set up a time. He never heard from them again. He received a call warning that he would be getting an email maybe a month ago or so. No, a subpoena. He subsequently received it by email. And then he received a call with no message this over the weekend, and that's where we are.
We are where we are. We'll work it out. Mr. Bulligrove, talk to me about the other witnesses that are proposed for today.
Your Honor, I think that other witness is going to draw a motion.
Oh, who is it?
His name is Todd Davis. I guess I don't know.
Detective.
Todd Davis. Your Honor, Mr. Davis was not on the state's witness list. They added him on Thursday, which I believe is in violation of Rule 16, and I would point the court to State versus Draper at 378 P. 3rd, 1261. In that case, the state had the manager of the store that was the victim of the theft on the witness list, and then later during trial added the assistant manager, and the Court of Appeals found it was an abuse of discretion for the trial court to allow that witness to testify without sufficient notice under Rule 16.
What was the amount of notice in that case?
I don't think it said exactly if it was but it was during trial. It said it was during trial that they announced that she was going to testify. And I don't recall if it was the same day, but the state's had months and months. We've had 8 amended witness lists, and I think to continue to add witnesses during trial is not sufficient under the rule.
Help me out, Mr. Bloodworth. What is is it Detective Davis?
It's Lieutenant Detective.
Okay.
Lieutenant Davis, right?
Sure.
He, Your Honor, the state is calling him to authenticate the May 4th, 2023 interview video of Robert Crozier in rebuttal to Robert Crozier's testimony. All he's going to do is authenticate the video.
Is that
That's the first I've heard that that's all he's going to do, but
is that issue in dispute? I mean, you reserve your arguments about whether there are other bases to bar the admission of that video,
which I believe there are.
but authenticity probably isn't one of them. Do we really need to call a witness, or can we just stipulate that it's authentic and then the parties will reserve their arguments regarding admissibility?
I would agree it's authentic, but yes, we would have other objections.
So can we just have a clear stipulation on the record that the May 4, 2023 video recording of law enforcement's interview with Robert Crozier is authentic?
Yes.
Your Honor, may I add to that the transcript of the video as well?
Is it a certified
It
transcript?
is certified.
I think that follows from the rule regarding certified transcripts. Ms. Lewis, do you agree?
I agree.
Okay. So it sounds like we don't need that guy.
Correct, Your Honor. We may as well use this time to litigate, I guess, what other objections to admissibility the defense has on the video.
Forgive me, the state is offering the video under which rule or exception?
Your Honor, 801, it'll be D1A, and perhaps some of it'll be D1B. The defense's cross-examination of Mr. Crozier elicited testimony that, and the state's direct examination elicited testimony from Mr. Crozier that was inconsistent with his testimony in the video. The defense's cross-examination elicited testimony that he was kind of out of it because of withdrawal and pressure to say certain things. And the video, rebuts that testimony. The video itself is, I think, 13 minutes long. And from the state's view, the entire 13 minutes, pieces of those 13 minutes are direct impeachment, but the entire 13 minutes goes to whether or not he was high and out of it, and whether or not he was pressured into saying certain things. Those pieces of evidence were throughout the entire 13 minutes.
The impeachment pieces, or the more specifically, the D1A inconsistent pieces, those would be, I think, fairly perceived off a cold transcript. The second piece, I'm not sure I or defense or you or the jury would be able to evaluate whether he was in a bad way from the transcript. Is the state seeking to admit both, or publish the video and admit the transcript? What's the scope here?
Your Honor, published both. We have the transcript running real time beneath the video.
Okay.
So that the jury can watch, listen, and read all at once.
All right. Ms. Lewis, do you have the video with the transcript?
I don't have them together where it
Okay.
shows it under. No, I have them separately.
Right.
I would
Sitting
like
here
to.
today, are you prepared to make a record regarding this, or do you need a moment to go through the pieces of, or to make argument regarding certain pieces of the transcript versus other pieces?
I think I would need a moment. I would like to see the video with the transcript
Sure.
run under it, and then, yes, I would need a moment. I would need some time to look at that.
Okay. We'll need to play this out a little bit. The state makes a facially, if not valid, at least thought-provoking argument under D1A, 801 D1A, that the video and the transcript related to it are categorically not hearsay. But having not seen the whole 13-minute video or read the whole transcript, and without the defense having the same opportunity, I can't make a ruling sitting here at the moment. So can we provide the video with the running transcript to the defense?
We can, Your Honor. I believe we placed it in box yesterday, but we can, if they want to, perhaps we can go into a conference room here and we can just play it off of one of our machines.
Sure. I mean, I would also understand if the defense said, hey, we just need an evening with it to go through it, collect our thoughts, have you make a ruling. Ms. Lewis, what's your request?
Depends on what is happening here next. I may be able to watch it now. I don't know where we're headed.
That's the thing, Your Honor. Those were our first two. That was our batter in the box and our on deck batter.
Okay.
So we are scrambling to get our in the hole batter here.
No, that's fine. These things happen. We're going to let Mr. Ramos continue to consult with Dr. Christensen. Ms. Lewis, Ms. Nestor, if you would have a conversation with the state about the video with the running transcript, let me know where we end up.
All right. Thank you.
Okay. Before we take a break for that, Mr. Bloodworth, anything else on the record?
No, Your Honor. Thank you.
Ms. Lewis?
No, Your Honor.
All right. Let me know when you're ready for me. Thank you. Court will be in recess. 500-139. Mr. Ramos, have you had an opportunity to consult with Dr. Christensen?
That's very helpful, Judge. We appreciate it. We're ready to go.
Okay. Mr. Burmester, anything before we invite the jury in?
No, Your Honor.
Counsel, anything before we invite the jury in?
No, Your Honor.
All right, let's do it.
We're ready for the jury.
I must stay put mostly, yeah.
Ladies and gentlemen, please have a seat as you come in. Please have a seat. Good morning. Thank you for your patience. We'll now proceed with additional witnesses in the state's case in chief. Mr. Burmester, the state's next witness, please.
Dr. Eric Christensen.
Let's invite Dr. Christensen in. Doctor, if you would step in front of Brittany, we'll get you sworn in, please.
Please raise your hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Yes.
Thank you. Have a seat.
Drag that chair wherever you need to.
Thank you.
Please proceed.
Thank you, Your Honor. Can you please state your full name and spell your last name for the record?
Sure. Eric Dean Christensen, last name Christensen.
Sir, are you employed?
I'm currently self-employed.
Did you were recently the chief medical examiner for the state of Utah?
Yes, I retired in 2024.
How long were you the chief medical examiner?
I began working as a chief medical examiner in July of 2016.
Did you then supervise Dr. Ulmer?
I did.
Are you familiar with the death investigation for Eric Richins?
I am.
And how are you familiar with it?
I'm familiar with it from discussions with Dr. Ulmer over the time she was evaluating the case, as well as my subsequent review of the medical examiner's file.
Did you have an occasion to talk to Kouri Richins?
I did.
Okay. Have you testified as an expert in forensic pathology before?
I have many times.
Okay. I would like to first talk to you about cause and manner of death and the statutory requirement for that process. When you have a death investigation, could you please explain how, I guess, what the manner of death choices are and what's the purpose of that, and just
Sure.
describe that for the jury,
Okay.
please.
So two of the things that the medical examiner is tasked with doing under statute is determining the cause of death and the manner of death. The manner of death is a box that we check on a death certificate that is essentially a one-word synopsis of the circumstances surrounding that person's death. The options available to us, we can certify that a death is a natural death. It can be an accident, it can be a suicide, it can be a homicide, or it can be, in Utah, the death certificate reads could not be determined, what most commonly is referred to as undetermined. And in those settings, undetermined essentially means we can't we don't have enough information to decide which of those other 4 options best fits.
What's the purpose of that whole exercise?
Again, it's something that's on the death certificate, and so it's part of the vital statistics function that the medical examiner's office provides. All of the deaths that we investigate and deaths that we certify provide information then back to the state. Sometimes that's public safety, sometimes it's Department of Health. Other people will utilize that death certificate data to evaluate the ways that people are dying within the state and attempt to intervene to minimize those types of deaths.
In this particular case, were you stuck between the first 4 you mentioned, such that you ended up picking undetermined or cannot be determined?
Yes, again, and just to be clear, I didn't sign the death certificate, Dr. Ulmer did, but certainly was involved in discussions around that. And the determination, making a determination of undetermined means that we generally can't decide between 2. In this case, I would say actually generally most cases where we certify death as undetermined, it's because in overdose deaths that we certify as undetermined, it's because I don't know enough about the person's own intent. We see it frequently in the setting, for example, of people that may have depression or other mood disorders, and maybe even prior suicide attempts, as well as they may have substance use history that they use to self-medicate their depression and things. And so if someone overdoses on a drug that they're known to abuse, but they also have depression, if they don't leave a note or something else, then I don't really have a means of, telling just from looking at that, did they mean to do this or is it accidental, incident to their normal drug use? That's the most common scenario in which we certify a death as undetermined. In this case in specific, we did not really have any concerns about suicide in this case, but there had been concerns related to our office that perhaps someone had done something to provide this to him and that he didn't just take it himself, but we didn't know. We had no idea how he got the stuff into his system. And so with that, we were left with undetermined.
So the choice there would have been, as opposed to accident and suicide, it was accident and homicide.
Correct.
Okay. Could you describe for the jury the way in which the body processes substances? In particular, I'm looking at opiates and the different ways they can be ingested.
Okay, there's a lot in that question.
Yeah, sorry.
Opiates can be consumed in a lot of ways. Even things, for example, like pills that you might get from your doctor for hydrocodone or oxycodone, opioid-related medications, those can be just taken by mouth as they're usually prescribed, but it's not uncommon for us to see people take those pills, crush them up, dissolve them in liquid, draw them up into a syringe and inject them. It's also not uncommon for us to see those pills crushed and then heated and people inhale the vapors from that, primarily as a means of getting the drug into their system more quickly. And there's lots of other reported ways that people use things, but those are probably the most 3 common ways that we see pills abused. People may directly inject just about any drug that's available in a liquid form. Fentanyl certainly is. Fentanyl is also available in patches and lozenges and other forms. And so it can get into the system in a lot of different ways. In terms of what your body does with it, fentanyl in specific is metabolized primarily by your liver. There's what they call a CYP enzyme that is primarily responsible for the metabolism of fentanyl in your liver. That metabolism is felt to be mostly determined by how much blood is flowing through your liver. So the more blood flow you have to the liver, the more rapidly it will be metabolized. There are other ways that sometimes people will metabolize it more slowly, but based on what specific genes they have for metabolism or for that metabolizing enzyme, but mostly it's a function of how much blood is flowing through the liver. And it's then converted very quickly, has a very short half-life in the body, minutes, and is converted to a substance called norfentanyl. which then is eliminated in the urine. Don't know if that
Once
covered
it,
all
yeah,
your-
that's great. Thank you. Once it gets into the blood, then what's the intoxicating effect? I mean, how does that function?
Sure. So fentanyl in the blood distributes throughout the body. It's absorbed either through the mucosa, the lining of the mouth, or directly into veins, whatever. It gets into the bloodstream. And then from there, it gets into the brain, it gets into other organs, where it exerts its primary effects on the brain and the central nervous system, where it causes respiratory depression and or cessation. Can also cause central nervous system depression, meaning it alters the way you think, can, make you groggy or, less than normally responsive and things. But its primary lethal effects are related to its effects on your breathing. And it is dose dependent. So a higher dose will do this more readily than a lower dose, but it will, either slow or stop your breathing. And sometimes that has lethal consequences.
The lethal consequences then are from stopping breathing?
Yes.
Okay. And when you stop breathing, death ensues. Does that metabolizing process continue to happen, or does that stop as well?
Generally, it will stop. There are, once your circulation stops and blood is no longer flowing through the liver, you're not going to have that continued metabolism through the liver. But there are a number of changes, large number of changes that are described in the way fentanyl is present in the body after death, that are related to changes in the pH of the body as you start to decompose, and other things that will influence what those levels look like.
When a person, I'm going to give you a hypothetical. So we have a decedent, and in the blood you and the lab personnel determine that there is quetiapine below the threshold of their tools. There is fentanyl at 15 nanograms per milliliter. And then in the gastric fluid, there is quetiapine at about 16,000 nanograms per milliliter, and fentanyl at 20,000 nanograms per milliliter. My question then is, based on that hypothetical, is there sufficient information for you to determine whether those two drugs were taken simultaneously or sequentially, and if sequentially, which one came first?
I can't tell you that.
There's just not enough information?
No, you can't derive that information from those values.
Okay. I just wanted to follow up. You said there's drowsiness as a consequence of taking, I assume, opioids of any type. Fentanyl just happens to be stronger?
Yes, fentanyl on a weight by weight basis, 1 milligram of fentanyl compared to 1 milligram of oxycodone or of morphine is the usual reference standard because it is the classic opiate medication. Fentanyl is just much, much more potent, 80 to 100 times more potent than morphine.
So you said there's depression of the respiratory system, drowsiness. How quickly might one start to metabolize, given the fact that they take some fentanyl and it causes their death? Would they be able to metabolize at least some of it?
You would expect so, yes.
Okay.
I mean, there are a number of overdose deaths reported in the literature where the death occurs so quickly, and these are primarily in the setting of intravenous drug use, that no metabolism is able to be recorded because they just die too quickly. But generally speaking, we see some level of metabolism.
Let me see. I wanted to. someone takes an overdose, a fatal dose of fentanyl, it's not then instantaneous death.
It depends partly, I mean, generally speaking, no. It's a function of the dose and the route of administration. So it's going to get into the system more quickly as an IV, or smoking will generally get it there pretty quickly as well. But ingestion would delay that somewhat, but however it gets into the body is going to determine how quickly that happens.
In this case, we have the two things, I think. One is there's some fentanyl in the stomach, the 20,000 nanograms,
Yes.
and also a measurement of, I know I'm saying it incorrectly, acetyl fentanyl.
Acetyl fentanyl, yes.
Does that is that information help you determine how it was ingested in this case?
It's suggestive that it's an oral ingestion. The presence of a large amount of fentanyl in the stomach, sort of the rough equivalent of several milligrams by volume is suggests that it was taken by that route, but there's not any way to definitely know that. There is some literature that suggests that the stomach will concentrate it, regardless of where it's from, but it is suggestive of that. And the presence of acetyl fentanyl in the stomach is also consistent with, is more consistent with this being illicit fentanyl than otherwise. Acetyl fentanyl is a variant of fentanyl that is, in our office, certainly we've only seen it in the setting of illicitly manufactured fentanyl.
When a body comes in for autopsy, in this case, Mr. Richins' body comes in, is it routine to check for injection sites?
Yes.
And
In this case in particular, there was visible pulmonary edema described at the scene, foam coming out of the mouth, and that is most commonly in somebody who didn't drown or have a history of heart failure is concerning for an opiate overdose, and so we would, in that case, do a thorough check for those.
Oh, for
injection
sites, and none found.
Again, I did not do the exam. None are described, and none were discussed by Dr. Ulmer.
Okay.
And I didn't see any in the photographs.
When you in cases where you've seen an overdose death, particularly an accidental overdose death where you suspected inhalation, what's the sort of evidence that you would expect to see?
I'm not sure what you mean. Inhalation of the substance?
Of fentanyl or opiates.
Yeah, I mean, they all kind of look the same from that regard. You may see evidence that they've been smoking. Sometimes you see little burns on their fingers or other things from heating it up to smoke it, because they're not actually smoking it in the same way that you smoke a cigarette where you light it on fire and then you're inhaling the smoke. What actually is happening is that drug is being heated up and vaporized, and you're inhaling the vapors.
So in those cases, do you tend to see evidence of that heating up? That is tinfoil or torches? Or
certainly, yes, those things can be present at the scene.
Okay.
Commonly are seen at the scene.
Okay. Now, is it common for the people who are left behind to call the ME's office to find out what's happening in the case of their deceased person?
I wouldn't say it's common, but it's not uncommon. I mean, I spend a lot of time, most days I was in the office speaking with family members.
Typically, that would be whoever did the autopsy would be talking to the person who's calling?
Yes.
Okay. Dr. Ulmer retired in January of 2023.
Yeah, technically, her last day of work was the end of December of 22.
Okay. And did you receive a call from Kouri Richins then?
I did subsequent to her retirement.
And did you return her call?
I believe I didn't return her call. I believe she was just put on hold and then connected with me.
Okay. Have you had an opportunity to listen to a recording of that phone call?
Yes, I'm not sure where it came from either, but yeah.
Is it consistent with your recollection of that phone call?
I did not have any independent recollection of it until I heard it, but yes, it's me on the phone call.
Okay. And have you had a chance to look at the transcript of it?
I have.
Okay. And is that accurate to your,
Yes.
when you listen to the
Yes, it
tape?
appears to be.
Okay. State would offer States Exhibit 2-60 and 2-61T.
He indicated he's reviewed it. Certainly we could ask questions if he needs his recollection refreshed. I think we could move to admit at that point, but if the state would just
I think
ask
the
us
state's
to point.
admitting it as evidence of defendant's words and statements in the relevant time frame.
I misunderstood. No objection.
And so, okay,
We'd ask permission to publish it then if it's offered and admitted.
so 2-60 is the audio recording, correct?
Correct?
And 2-61T is the transcript.
Correct, Your
Okay,
Honor.
those two are admitted. Scott, give me just a moment here, sir. Give that a try.
Okay. I'm going to ask you to listen to this. It's about 9 minutes long, and then I will ask you 3 questions regarding it. Okay, thank you. Can we advance it 30 seconds?
Thank you
The
so
first
much.
30
Thank you
seconds
so
is-
much.
Okay.
Okay, sorry about that. I'm going to transfer you right now, okay? Thank you so much. Thank you so much. No problem.
I'm not hearing it.
Did we lose it, Scott?
I think so.
All right, no problem. Let's start over. We're getting quicker at this. Scott, if you would disconnect and reconnect on your end, I'll do the same on mine.
I'm going to transfer you right now, okay? Thank you so much. Thank you so much. No problem.
Is that Chris?
Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of
Right.
you?
I do. Yeah, I got
Okay.
the file here.
Scott, did we drop that again?
Yes.
All right, I apologize, folks. Let's try that again. Scott, if you would disconnect from the system, thank you. Then reconnect, please.
Seeing if we do any additional microscope.
I'm going to transfer you right
So much.
Thank you so much. No problem.
Is that Chris?
Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of
Right.
you?
I do. Yeah, I got the file here.
So can
Yeah, so
you,
just so you know, so we issue supplemental reports, like if once the original report's issued, if we do any additional testing, if we do any additional microscopic examination, anything like that, then we include that. You know, we issue a supplemental report to include that additional information. And sometimes it does change the cause or manner, but in this case, it didn't.
okay, it was just like extra testing done?
Extra tox testing, yeah. So originally the testing, the only toxicology testing that was done was on blood. And so then this was additional testing on stomach contents.
Okay, and so is there difference in that, I guess?
Well, they just tell you different things in the sense of, it tells you something about what, was it, is it been there a long time? Is this something the person's been using for a long time?
Okay.
Is it something they ate? Is it something they, injected? Is it, whatever? And there's different things you can learn by looking at different substances. I mean, we fully expected to find it in the stomach. It's just a question of what was there.
So does does this tell you like if it was like injected, if he ate it, is that what this, can you tell from this report?
Not definitively. I mean, it seems like, with what the amount that's there, that it probably was ingested. Probably taken by mouth.
Okay, and so the 15 ng, like, is that like a substantial amount? Is that like a trace?
That's a lot of fentanyl in the blood. Yeah. I mean, that's, people die with half that amount or less in their system.
Okay, so that's quite a bit.
Yeah.
So what's the next one down, the norfentanyl?
It's a metabolite of fentanyl. It's what your body changes fentanyl into after you take it.
Oh, I gotcha. Okay. And then, sorry, just the third one, the acetyl, I don't know how you say that.
Acetyl fentanyl.
Oh.
Yeah, that's just it's a form of, it's a variant of fentanyl that is usually only present in the setting of illicitly manufactured fentanyl.
Illicit manufactured, like a pharmacy?
No. Most fentanyl that we see that, ends up leading people to die these days is related to, fentanyl that's manufactured by drug cartels as opposed to by pharmaceutical companies.
Oh, good Lord. So this is like more of like a cartel. No, I mean, that's not what it is.
You call this the street fentanyl as opposed to, hospital
Prescription.
fentanyl.
Okay, I see. And then is the ethanol, is that alcohol?
That's alcohol. Mm-hmm.
Okay, and is that like the 279? Is that kind of like a substantial amount, or is that like one drink? Is that 5 drinks?
You can't tell how much it is, and in this case, since this testing was sent, quite a long time after the original autopsy, most likely that's related to, postmortem change, but it could be stuff that he drank. There's not really a way to sort that out. It could be related to decomposition of the stomach contents, or it could be related to stuff he drank. But either way, in the stomach contents, there's no way to know what that level means in terms of, if that was a blood level, that would be the same as a 0.28, which would be, that person would be pretty substantially intoxicated. But because it's gastric contents, you could in theory pull something out and it would be, 100% ethanol, if, depending on if they just drank a stomach full of, if they just drank a bunch of Everclear or something else.
Mm-hmm.
So it doesn't really tell you much about how much they drank or what they drank or anything like that.
I gotcha.
In the stomach. And it's not present in his blood, so.
I gotcha. Okay. So it's not present in the blood, just the gastric or whatever.
Right.
Okay.
Yeah.
And then just the last one, what is quetiapine?
Quetiapine Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay. I gotcha.
It's a prescription mental health medication
Mhm.
that's prescribed for different things.
I gotcha. Okay. And it has like 16,000?
16,000 nanograms per milliliter. Mm-hmm.
Okay. And is that, I mean, quite a bit? Like,
It
can that,
that's a big number, but it doesn't really mean that much. You know, so a nanogram is a millionth of a gram, and a gram is not very big. So even 16,000 of them is not a huge amount.
okay. Is there like, could those have been mixed? Or is that not kind of a
What's that? Could what be mixed?
quetiapine and like the fentanyl? Or is that like a normal, I guess, drug thing? I don't know. Like,
It's not, most of the time if we see those together, it's because somebody was taking quetiapine as a prescribed medication and they were abusing fentanyl. But, there's,
okay.
do you have any indication he was abusing fentanyl?
No, that's why all of this is just like, what the heck is this and going on? So I guess that's why I'm confused just about all of this, honestly. So I don't know. So, I know it doesn't mean anything now, but just kind of something for me to, try and figure out, I guess.
Yeah.
And then I'm assuming the acetopin, is that like a aspirin or something?
Acetaminophen, that's just
Oh.
Tylenol. Yeah.
Oh, that's fentanyl too?
No, that's Tylenol.
Oh, Tylenol. I was like, holy shit. Okay.
Yeah.
So just like Tylenol, caffeine, and then the naloxone, I'm assuming is just something that they gave him while he was here.
Probably would be my guess. It'd be, somebody that's unresponsive. It's a very common thing for EMS to give people.
Okay. No, that works. I was just trying to figure out, if this is anything different, if we found out anything new with this up.
Oh, come on.
Pause there. It's okay. We can fix it. Scott, don't change anything. It seems like if I do this, press play.
Yeah, like she said, it doesn't change anything in the cause or manner of death. It's still, definitely, death from fentanyl intoxication, and we still don't know how he got it into him.
Yeah. And is that anything you could ever find out if it was, do people normally eat that? Like take it, is that something you like shoot?
It's not usually something people eat. Well, that's not even true anymore. So with illicitly manufactured stuff, sometimes people take pills that have that. So yeah, these days you can't really tell.
Yeah. All right. Well, I appreciate your time. I do. Thank you very much. And
Yep. If you have other questions, don't hesitate to give me a call.
Okay. Awesome. What was your name?
Dr. Christensen.
Oh, Christensen. Okay. Perfect. Thank you so much. I appreciate it.
Okay.
Okay.
Yep,
Bye
you're
bye.
welcome. Yep.
I'd like to follow up on a couple things there. You mentioned to her about if the gastric contents were blood, it would be 0.28
Yes.
blood alcohol, but it's in fact not in the blood, it's in the gastric. And so there's no way of conveniently figuring out how much it is, much less its source.
That's correct.
Are you okay? Do you need?
I've got water. I'm good.
Okay. You mentioned in that call, at first you said we typically don't see it eaten, but you can't say that anymore. Could you expound upon that? How, in cases where there's pills, is it common to see them eaten?
So, yeah. Okay. A few things about that. So over time, I'd say the last 20 years, we saw a rather dramatic change in the deaths we saw related to fentanyl. Until the early 2010s, pretty much all fentanyl deaths were related to prescription fentanyl being used incorrectly, most commonly by healthcare providers and other people who would, have access to it and would abuse it. And it was just not a common thing. We just didn't see a lot of deaths related to that. Once patches became available, which were designed, primarily for, treating cancer patients with bad pain and things of that nature, people became creative with how they used those patches as well. Some people would, put on multiple patches, or they would put on patches and a heating pad to sort of drive it into their system more quickly. Seen people that would smoke them, people that would insert them into their rectum, people that would chew them up. Sometimes we find, multiple chewed up patches in the stomach. And certainly other ways have been described as well with patches. But once the illicit drug supply and primarily the heroin supply came to be, either augmented and or replaced by fentanyl, we saw, we saw much less in the way of the, prescription abuse and much more of the illicit stuff being used. And some of that was in the form of what was heroin. Most heroin in this area was black tar heroin, which then became, ended up having fentanyl within it. So people that had been heroin users would still be using what they thought was heroin, and it would have fentanyl in it, many times mixed with heroin. Eventually, some cases was not mixed at all, but was just straight fentanyl. Counterfeit fentanyl pills, or counterfeit oxycodone pills. Fentanyl in pill form, made to look like it was an oxycodone pill, also became a fairly common thing. And as we discussed before with other pills, people will abuse those in different ways. Sometimes they can ingest them directly, but they can also grind them up and inject them or smoke them. So they can be used in all kinds of different ways. But in the phone call, what I'm referring to, we mostly did not see anybody eating fentanyl before illicit fentanyl. With the advent of these counterfeit pills, we saw it somewhat, more often, or would assume that was the route. But we, even then, most of the time don't know how somebody gets the fentanyl into them, even if they have it on their person.
In this case, there certainly wasn't any injection sites noted.
No.
Are there tests, forensic tools that could aid in the determination of whether one is a chronic or habitual or a naive user?
It's a good question. So there's been a lot published on the assessment of fentanyl levels in people that have died, and ways that you can try and parse some of those things out. The bottom line for all of them is you can't look at a number in isolation and make a determination based on, this is a lethal level, so this level has to be the cause of their death. There are certainly people who, become tolerant. Most opioids, people will develop tolerance over time, and so they can have very, very high levels and not have the same effect as someone who doesn't take it all the time. We had no history in this case in particular to suggest long-term chronic use, but also didn't know. And there are things that could potentially be looked at to try and assess longer-term use. The only published data I've seen around that revolves around comparing the fentanyl to the norfentanyl level, and levels where that ratio is more than 8 are believed to be consistent with an acute intoxication. Ratios of 2.5 or less are consistent with chronic use. In this case, that ratio is about 4.6, so it's right in between. So it doesn't really provide us helpful information either way.
That's the ratio between fentanyl and its metabolite.
Correct.
As you find it.
Yes.
Have you ever heard of pseudo-allergic reaction to opioids?
Yes.
Could you tell the jury a little bit about that?
Sure. most allergic reactions are because the body has developed an immune response to some specific protein substance, whether it's nuts or grasses or whatever, pollens of different types, and your body reacts to that and triggers a reaction through your immune system that elicits what we typically think of as allergy symptoms that can range everywhere from, a stuffy head all the way up to anaphylaxis and death. In the setting of opiates do not elicit a true allergic response, but there are many people that take opiates who have an allergic-like reaction, but it's because the drugs themselves are directly triggering those cells that cause those symptoms as opposed to going through the immune system route. And so some people will, that chronically take opiates and opioids for pain, will pre-medicate or medicate around the same time with things like Benadryl and other things to minimize those symptoms because they know they have that reaction. Certainly most people that take them do not have that reaction, but some do. And that's
if one didn't know and one took some opiate, could they have hives and those sorts of allergic-like responses?
yes.
Given all the symptoms that you talked about, the lungs, the edema, and the data from NMS labs, do you have any concern about the cause of death in this particular case?
No.
And the 15 nanograms, as you explained to Kouri Richins, was a lot.
Yes, it's well within the range of levels that we see in people that die from fentanyl.
Do you remember when that phone call took place?
Do I remember what?
When that phone call took place?
I don't off the top of my head.
Okay. Does your office take notes when you receive calls and reply to calls, et cetera?
Yes.
Okay.
That changed a little bit over the time I was there. It used to be we'd get a little scrap of paper with a note written on it, return this call. And we turned that into a digital log before I retired, but yes.
Would it help to look at one of those notes to refresh your recollection as to when the call took place?
Sure.
May I approach the witness?
Of course.
Do you recognize that, sir?
Yes, this is from the log. Just said that an incoming call came to me from Kouri Richins, and she had questions. And that this is my notes.
And so what day did that phone call?
On January 12th of 2023, a couple
Thank-
weeks after Dr. Ulmer's retirement.
Thank you. That's all.
Could I get some more water?
Of course.
Thank you.
Good morning.
Good morning.
We've spoken before. I'm going to ask you some follow-up questions to Mr. Burmisters.
Sure.
I'll start off with that final thing that Mr. Burmister showed you. You indicated that you would take calls from different individuals, correct?
That's correct.
And did you receive other calls in this case from law enforcement?
I believe I did, yes. Mhm.
Would it refresh your recollection, or do you recall a call around the same time in this case?
I don't recall the timing of it.
Yeah, I'm going to approach you with the same case notes. And it's that first one.
Yes.
And did you in fact receive a call before Ms. Richins?
Yes, the day before.
And was that law enforcement?
It was.
And was that also regarding the supplemental report?
Yes.
Okay. And either your recollection or what's in your notes, do you recall if most of the questions were the same that Ms. Richins asked you on the 12th?
I don't have any specific recollection, but my, general recollection was that we discussed the supplemental tox findings.
Perfect. I'll take that back. Now, the questions that we just heard Ms. Richins ask you, very similar to what we're asking today, correct?
Yes.
I'd like to talk to you about the allergen discussion you just had. You indicated that perhaps an individual could have a reaction like hives.
Yes.
If someone is allergic, in this case to an opioid, as you indicated, does that allergy disappear?
I'm not sure what you mean. Does it go away over time?
Over time or within a certain amount of time? Or
I mean, allergies certainly are things that can fluctuate. People can receive treatment and their responses to different things will go away.
were there hives on Mr. Richins' body, to your recollection?
No.
We were talking about illicit fentanyl and counterfeit pills
Yes.
containing traces of fentanyl.
Milligram amounts.
Okay. Now, the tablets that or pills that would contain these traces, what kind of pills would those be? Generally.
Objection. The discussion, if we're talking OxyContin, is that what you were saying?
I've not said it. I've just said pills.
Okay. Well, there's no pills that they have that you can make.
Would you provide a little more foundation for your question so
Sure.
we know what we're talking about?
Absolutely. Your testimony just now was that in your experience, you started to see that fentanyl or fentanyl overdoses were coming in through your office, correct?
Correct.
And in those overdoses, you gathered information, and because you would see that there was a presence of acetyl, I say that right? Acetyl fentanyl?
Acetyl fentanyl. Acetyl is also fine.
Okay, acetyl fentanyl. that was more likely a result of illicit fentanyl, correct?
So it is a form of fentanyl that in some cases there were a variety over time of different fentanyl variants that were developed primarily in response to controlled substance legislation. If fentanyl is outlawed, then we'll add an acetyl group to that molecule, and then it's no longer controlled. And so we can distribute that as a non-controlled substance. And then that one gets controlled. And so then, there were dozens of variants of fentanyl that were developed over time. Acetyl fentanyl was one of the more common ones that we saw early in this wave of progression, but was one that we saw not infrequently.
Now, with that, what was the acetyl fentanyl contained in, usually in your experience?
I don't recall ever having seen acetyl fentanyl in a substance form in any of our specific cases.
Because it was always inside whatever pill or however it was administered, correct?
I don't even know if it was pill administered. I don't know.
Or injection.
Or I don't know how we would see it in people, but I don't recall ever seeing that correlate with a specific pill that we had tested that was shown to contain that. I know generally the crime lab identified acetyl fentanyl in some pills, but I don't recall a specific instance in my casework where those two were correlated.
Describe counterfeit pills.
Counterfeit pills are essentially illicitly manufactured pills, and sometimes very sophisticatedly, where people will buy the same kind of a pill press that a drug manufacturer uses, and they put their stuff into it and press pills that look very, very similar to legitimate prescription pills. The most common counterfeit pills that we've seen have been fake 30 milligram oxycodone pills that, when tested, contained only fentanyl. And there are also some benzodiazepine pills, things like Valium and Xanax and other things where those, what look like Xanax pills, have also contained fentanyl.
And you just indicated two different things, that in some instances, it was purely fentanyl. Those pills contained only fentanyl, correct?
Correct.
And then there were other times where perhaps they were still traces, or there were still the other benzos, for example.
Those would be different pills. I don't know.
Sure.
I'm not aware of any where it was both.
That much longer, obviously. And it covers all of the same lines, of just much more concise.
So I would need to include in, because what's not covered in that is the intervening act, which I could then take from the pattern unless there was, let me see if there was. Valentine has some other language, as when the intervening act was undertaken by someone other than the defendant who could reasonably be expected to take that action in response to criminal conduct. I'd have to pair that with something else. Having to prove whether the intervening act itself was a natural or probable consequence of the defendant's conduct. But the language that we have in our packet for Valentine just doesn't address the intervening act. But like I say, I could charge what I'll just call the Valentine language as the first part of approximate cause, and then charge the pattern on the intervening act, which I think you'll see that starts with a bracket on page 10, if the evidence raises the issue of the intervening act.
The way I understand it, Your Honor, you're going to start with the state's request proving all the way down to not merely a possible result, taking out the last sentence. And then going to the top of the page, there may be an intervening act.
That sounds right. Yes.
And then taking out or if the defendant's conduct materially accelerated the death.
Yes. And I would charge, I guess, the very beginning of 14160 to find the defendant guilty of murder in the second degree, cruelty to children, involuntary manslaughter. Actually, I guess every count, including the reckless conduct here, the state must prove.
Should you take out the individual charges, say that to find the defendant guilty, the state must prove?
Could say that. I mean, it covers
It's basically every count.
For the record, Mr. House should have said this. So I think that is probably adequate and safe unless somebody disagrees.
Nothing to say, Ron.
look at, it's somewhere just above proximate cause, the involuntary manslaughter, lawful act, also there. So the pattern stops after, so you got the three numbers, and then you got to prove involuntary manslaughter, state must prove the defendant acted with criminal negligence. And then the bench notes, you have to define criminal negligence, which I would have already done. But this stuff that's below that it's down in a bench note, and it appears, I don't know why it's there. That's the reckless conduct language that pairs with the other form of involuntary manslaughter, and we generally don't ever tell a jury what's a felony and what's a misdemeanor anyway.
I think it's confusing, or could be confusing.
I'm sorry, just starting.
Where it says the state must prove the defendant acted with criminal negligence,
Mhm.
what I would add is, which has already been defined for you, because I did that a couple of charges ago. But then what's below that, I don't know why that's there. It's actually, it pulled it up from a bench note. It's not actually part of the pattern charge or the law for lawful act in an unlawful manner.
So you're just gonna say as already defined?
Yes. I just want to make sure I didn't miss anything. So Danielle she'll print a clean final version for each of you. Page, I think it's 7, 14112, presumption and inferences. I've got concern about that charge because usually that is something that would go with intent. And we've taken the intent charges out because these are all criminal negligence charges, with some form of criminal negligence. So I'm inclined to take that out. It worries me. It really is in the intent section because we're generally talking about intent crimes and here we're talking about negligence. I don't think the state loses its argument because they're going to get the natural and probable stuff, the foreseeability in proximate cause. So since we've removed the intent from the other ones, I'm going to take it out here. Does anybody have questions? And I know you don't have your final version, but I'll give it to you. What I will probably do, since I know closings will be lengthy, is just take a break after the closings. Let everybody look at that final packet one last time, just to make sure I don't say something that's error. Any questions?
No, Your Honor.
All right. So as far as I know, the jury's not here yet, and if y'all need any, additional time, let me know. It's okay if they sit there for a little bit.
Judge, during the break, I had an opportunity to go through most everything that the state has. We do have some objections to certain items. I don't know when you want to take that up.
Yeah, normally I would do it now, but I want to make sure we get this done and we can come back and handle that after closings and charges. Okay, so we'll do it, of course, but let's get this, the dust settled here. Anything else?
No, Your Honor.
Thank you.
And I think with the red box, the issues on the PowerPoint stuff.
statements to Mr. Crozier, statements from Nicole Cummings and Carmen Lauber. So there's those hearsay statements in there also. And the other thing is, it says that it can be admissible under 801D when the person is subject to cross-examination. I know Mr. Crozier was subject to cross-examination, but he's no longer subject to cross-examination. It seems as if this video should have been introduced prior, because then we would have had the opportunity to show him portions of the video and cross-examine him on the video. That opportunity is now lost.
Why?
Well, he's been released from his subpoena. We don't know if he's been out talking about the case, I suppose.
Well, you could ask him about that, but he's not unavailable.
Well, that's correct. We could subpoena him and bring it back in. That's true.
And I just want to make sure I understand the procedural history here. Defense had the video, right?
Yes.
To the extent it had wanted to cross-examine him regarding the video when he was on the stand, you had the opportunity, and there may have been good reasons to not do it at the time.
Well, the main reason was he had no memory of it, so that made it difficult.
Well, that's exactly the condition that triggers 801D1A.
Well, 801D1A is if there is inconsistencies in it.
Or has forgotten.
Yeah, I'll take your word for it. I don't have it in front of me.
I mean, I think that is the basis to have a discussion regarding admission of the video, his side of it, right? Under 801D1A, is that he was testified numerous times under oath in open court that he couldn't remember the interview, right, even to the extent of saying that piece of transcript does not refresh my recollection.
Correct.
So I can instruct the jury to not consider anything other than Mr. Crozier's statements for the truth of the matter, that they can only consider the law enforcement have for context, as to provide context for why Mr. Crozier is responding. Other than that, any other hearsay concerns?
No other concerns.
Any other concerns?
No.
You had two reasons, you said.
Yeah, I gave them the hearsay of the other people.
And, okay.
They're subject to cross-examination.
All right.
On the video.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
How would you propose we do this, Mr. Bloodworth? Play the video with the scrolling transcript for the jury nowish?
Yes, Your Honor. Maybe in 5 minutes-ish.
Sure.
Stay, drink a lot of coffee.
No, you and I both. Let me make a ruling here and see if either side needs clarification.
Yes.
Mr. Bloodworth, as I understand it, the state seeks to admit and publish to the jury a 13-ish minute audio-visual recording of Mr. Crozier's interview with law enforcement in May of 2023. The recording is accompanied by the transcript that plays below the video in real time. Is that correct?
That is correct, Your Honor, and it is labeled 8-64, D as in dog.
Okay.
Can you repeat that?
864.
Thank you. Having had the opportunity to listen to Mr. Crozier's sworn testimony in open court, and given that defendant had the opportunity to cross-examine Mr. Crozier when he was on the stand, has had the video, and that there's no evidence before the court currently that Mr. Crozier is unavailable to be re-subpoenaed and brought back into the courtroom by defense if they determine it's necessary to do so. The court determines that Mr. Crozier's half of that interview with law enforcement from May 2023 is admissible as categorically not hearsay under Rule 801D1A, because he testified under oath that he couldn't remember the statements he gave during that interview. And therefore, these statements that he makes in the interview qualify as statements regarding which he has forgotten, quote unquote. The court will instruct the jury that they cannot consider any portion of the law enforcement side of that interview for the truth of the matter, which resolves any hearsay issue with regard to the law enforcement half of the interview. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Lewis?
No, Your Honor, nothing.
Okay. It will be. 8-64D, as in Delta, is admitted on that basis. Let's take a 10-minute break. This clock in here shows 20 of 11. We'll come back at 10 of 11. Thank you.
Before we
Yes.
may we get just the lineup, just so while we're on the break, we can take advantage of that and be prepared for whoever.
Who's coming in? after
Yeah,
that?
it hasn't changed from what I emailed you on Saturday, so I think.
Okay, perfect.
All right, folks, 10-minute break. Thank you. Court's in recess. Please have a seat, folks. Thank you. All right, have a seat. We're on the record. Mr. Bloodworth, I understand, will be admitting State's Exhibit 8-64D, a recording of a May 2023 interview with Robert Crozier. Is that correct?
That is correct, Your Honor. The state moves to admit and publish 8-64D.
Ms. Lewis, any other objection other than the one I've already ruled on?
No, nothing further.
Okay. State's 8-64D is admitted. We'll get that queued up now. Please proceed.
Robert? How are you? Confused. I imagine you are. We'll get to why we're here in just a minute real quick. Let me just get a little basic information from you, okay? How about an address for you? 16 East, 350 South. South, what city?
Your Honor, I'm so sorry, but you were going to give an instruction?
That is true. I appreciate that. Thank you for the reminder. Ladies and gentlemen, Mr. Crozier's side of this interview, this conversation, you may consider that for the truth, give it as much weight or as any as you determine it deserves. There are other speakers during this conversation. So the other side of the conversation, there may be 2 or 3 other people on the other side of the conversation. You cannot consider any of what they say for the truth. The only thing you can consider them for is to explain why Mr. Crozier is responding or to provide context for his responses. But the non-Robert Crozier side of this conversation is hearsay that cannot be considered for the truth. Anything further, Ms. Lewis?
No, Your Honor.
Okay. Please proceed.
We've lost the audio now.
That's all right. I'll fix it. Scott, please give it a try.
And a phone number for you.
County.
Yeah. We'll get to it.
I'm about to say, I haven't been in Summit County.
I know you haven't, but you've had involvements with people in Summit County that we're looking at. That's what we're here to talk to you about. Phone number for you, Robert.
385. I couldn't even tell you. I'm so confused right now.
Okay.
I really can't. My phone's new anyways.
Okay. Tell me your phone number then.
No.
Okay. So we'll get to why we're here to talk to you in just a minute. But before I do that, I'm going to advise you of your rights because you're obviously in custody here at jail, okay? So you have the right to remain silent. Anything you say could be used against you in court. You have the right to talk to an attorney with you during questioning if you wish. If you can't afford to hire an attorney, one will be appointed for you before questioning. If you decide to answer questions now that having a lawyer here, you can stop questioning anytime until you've spoken to a lawyer. You understand those rights I've explained to you? Having those rights in mind, you want to talk to us today?
Talking now.
Okay. So we're here to talk to you about a transaction that you made a little over a year ago with a female named Carmen Lauber that Nicole put you in touch with. You met her at a Maverick and Draper on 2 separate occasions in February of last year, so a little over a year ago.
Okay. It's not
Ringing a bell at all?
not ringing. It's in the bell.
Okay. Well, let me give you a little more information then. So we've talked to Carmen, we've talked to Nicole. We talked to Nicole yesterday, got her phone and downloaded everything we needed off of her phone. You sold Carmen blues on 2 separate occasions there at the Draper Maverick. As a result, somebody died from that transaction. So we're not interested in jamming you up or anything like that. We're simply here for information. But we know that you sold those and we can prove that through cell phone records and that kind of stuff. But right now, your information for us is more valuable than you being charged federally with selling fentanyl that results in death. Like, now you're hearing in on some drug stuff. Do you know anything about the federal rules with fentanyl and M30s and
I don't know anything. I know I've got a distribution of, I got a cop of 30 of them in December.
the M30s.
Yeah.
Okay. So tell us what you know. Like I said, right now your information is more valuable, but at this point we can prove, we know that you met with Carmen that Draper Maverick on 2 separate occasions, sold her fentanyl. That fentanyl was then used in a death case, basically. So we tracked it back to this point, but we're not interested in jamming you up. We're here to try and corroborate information. Validated.
I know
what Carmen and Nicole have both already told us. So you're in the position right now of either telling us what you know about it and basically not hurting anybody because Carmen and Nicole have both already talked to us. We're tracking you here and you're verifying information that we have. Or if you don't want to talk to us, that's fine. We will pursue it federally because we know that you sold them the fentanyl that resulted in the death. So that's kind of where we're at. And I'm not trying to bullshit you. I'm just kind of laying it out exactly how it is right now.
So I know who Nicole is.
Okay.
About a year ago.
February 5th and 25th is when Carmen messaged Nicole. Nicole gave her your information.
Okay.
Then you guys set up 2 transactions at the Maverick and Draper.
Okay. Of last year?
Yes. So not this previous February, a year before that. It's been a bit.
Yeah. And be honest with you, I'm still quite a bit of it. So, I'm not trying to be a douchebag or nothing, so it's hard. Remember that much time passed. And do you have a number that she bought from me? Was it a quantity?
She said between 20 and 30 pills both times.
Okay. Then probably, yeah.
Do you remember going to that Maverick and Draper? Were you living down there at the time, or?
She lives, I want to say she lives pretty far away.
She lives in Heber.
Yeah, so like that was just where we were meeting.
Where were you coming from? Where were you living at the time?
I've been living a little bit everywhere. Okay. Maybe the last couple of years.
So it's kind of ringing back. You're kind of getting a little bit more. Well, tell me what you can remember about it.
I remember Nicole calling me and saying, "Hey, can you be my friend?" You know, if I did. And then she was like, "Oh, she wants a lot." And I was like, "All right."
Is 30 a lot for you, or is that a lot for Nicole?
I think it was a lot for Nicole. It wasn't a lot for me. But okay. I was like, I didn't know anybody died. You know what I mean?
Yeah, and we didn't expect that you knew that. And like I said, that's why at this point, your information is more. We're not interested in jamming you up or the distribution of it or anything like that. We're doing our investigation. You're kind of just on the edges of it a little bit as kind of an involved player, as being a hook basically for it. We're not interested in jamming you up or anything like that, but we are interested in the information you have to provide to us that validates what people have already told us.
Okay, as far as I know, yeah, I met her just 2 times. I think I talked to her a couple more times after, but just to see, you know what I mean? Hey, you know, because somebody's spending, you know what I mean? You know, $500-600
Is that what 30 would run about $500 or $600?
Yeah,
so
something like that.
Okay. And did you hit her up afterwards to see if she wanted more, or did she hit you up afterwards?
I think I asked her one other time, and then she just didn't.
She's like, "Hey, you looking for any more?" or something.
Yeah, something like that. She just didn't respond to me. You know what I mean?
Do you remember how you contacted her? Was it through text messaging, a messenger?
I want to say it was through text messages, but I haven't had that number the longest time.
What phone would it have been on?
My phone. Fuck. Maybe a 333-6156 number.
You still have that phone? Okay. The phone you have now is a newer one then?
Yeah.
Okay. Have you contacted that guy Carmen at all? Not phone or anything? No. Do you know where that old phone would have been that would have had those text messages on it?
No, I lost that phone. A lot of it.
Okay. But what did you think the phone number was, you said?
385-333. 615.
Okay. So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted, you know.
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxygen? What did she ask for?
No. I think she might have asked me for blue. I can't remember.
But you sold her M30s, right?
Yeah, I told her what she knew what she was buying.
Okay, so it wasn't like she's asking for oxys or something like that. She got the M30s.
Right, no.
Okay. So she knew that there was fentanyl in those pills.
Absolutely.
Okay. You remember where you got those pills from?
I don't. Specifically.
Okay. What else can you tell us about that? That's all we're here to talk to you about was that transaction, those 2 transactions, I guess, a little over a year ago. We don't care about anything else, but what else can you remember about those?
She was with the older guy.
You remember what kind of car they showed up in?
No. Well, I think one time it was like a truck, like a white truck or something.
Okay. When you say she was with an older guy, do you remember about ballpark how old he would have been?
I don't know, 50s probably.
You thought maybe one time in a truck, but you couldn't remember the other one.
No, they were in a car the other time. I don't remember what car.
Okay.
The first time she was in the truck, though, for sure.
When you guys would have shown up with the Maverick, where would you go? Would you go around back of the Maverick or just right there?
Right in front.
Yeah. Just a quick hand to hand.
Yeah, there you go.
And it's just about $600 or so of what you charge for those. Okay. Do you remember? So I think she would have ordered more the second time. Do you remember the quantity?
I don't remember the exact.
Maybe remember being there twice.
Yeah. Okay. I really remember meeting her twice because you guys told me that there twice. I would have said once.
But do you remember now they're kind of jogging your memory?
Yeah.
Okay. Do you think of anything else about those meetings with her or anything?
No, that's the only 6 times I've talked to her.
Okay. How do you know Nicole?
This dude named Cam. I was staying with him, Roy, for a while. And she stayed there for a while, and then she took off, and then Cam's a fucking widow, and we were taking off one point or another. So.
Okay. So Nicole just hit you up and said, "Hey, would you want to be with my friend?"
Yeah.
You're like, "Yeah, that's cool." We were in the apartment. Did she call you or text you? Do you remember?
I believe she called me.
All the time, or just that one time? Or?
I think she was like saying with like two taking like, "Hey, what's up?" And then one of us called the other one.
Like, I'm Nicole's friend or whatever.
Yeah.
Okay. All right.
How long was your
Like, I'm Nicole's friend or whatever.
Yeah.
Okay. All right.
how long was your
I think she was like saying with like two taking like, "Hey, what's up?" And then one of us called the other one.
Ooh, would you press pause? We'll fix that.
Yeah.
My apologies. Go ahead, Scott.
Out there, or drug court or some shit, wherever she was living. She was on, she was either on AP&P or on drug court or something. I don't remember, and then she had to hurry. It was always in a hurry, like, she was like, "Okay, well, I'm leaving here now, so I can meet you like halfway. Can you meet me halfway?" Oh, yeah, I can do that.
And halfway was that Maverick there?
Yeah.
Draper.
Yeah.
Okay. You said one time she came with an older guy. Do you remember if that was the first time or the second time?
I believe it was the second time.
First time, do you remember if she showed up with anybody?
I don't.
Okay, I think those are all the questions we had for you. If we have any more follow-up questions, you want to talk to us again as we kind of progress with this a little bit further?
Yeah.
Okay. I appreciate you talking to us, Robert. Like I said, we're not here to jam you up over anything. We're just here to try and get some information and see what you
I
got.
don't fucking one day wake up with some fucking manslaughter charges.
No, we're not going to pursue that. Like I said, if you didn't want to help us out or anything, we kind of have this view right now that the people we're interviewing, we've got enough information. We're just trying to verify it. You're kind of either helping us out or you're not. And if you're not, you might, honestly. But all you've done right now, so we've already talked, Carmen's already talked, and Nicole's already talked. So you're not telling us anything we didn't know. You're not protecting anybody by not talking to us. All you'd be doing is basically rolling the dice with your future if you didn't want to talk to us, in a sense, because when the deaths are involved, the prosecutors do get a little spun up over it. And with fentanyl in the federal system, if you don't know this, if you get caught dealing fentanyl that results in a death, you could potentially face federal charges. It doesn't matter if you intended to cause the death or anything else like that. They're cracking down on it. So I don't know how long you're in for with. I know you're in possession with intent stuff, but if you are still dealing, don't be dealing with that shit anymore because the feds are coming down hard on it, and it's only a matter of time, especially with how nasty that shit is.
And most of this gave me my name.
Well, we already verified it through phone records. We already knew who they got it from. It wasn't like they told us anything we didn't know either.
Yeah.
We've been able to find everything we need through digital evidence, and all the contacts, all the messages on Facebook, all that stuff.
Yeah, we knew all of that before we made contact with anybody.
Yeah.
So it wasn't like they were diming you out or anything.
Yeah, but I don't think me and Carmen even were friends on Facebook.
We actually were the ones that brought up your name to Nicole because we already knew that Nicole had put you in touch with Carmen, and we already knew all of that information.
Oh, okay.
So We're just trying to verify stories is all we're trying to do at this point, so. Do you have any questions for us or anything like that?
Other than this isn't gonna backdoor me here?
No.
No? All right.
We're not here to jam you up or anything like that. We don't give a shit about what's going on down here or anything like that.
But I was just going to ask you: do any of your people ever tell you what they're going to use it for themselves? If they're going to try to sell it to anybody else? What their intents are?
Everybody that I deal with does it themselves. You know what I mean? Like I do it myself, they do it themselves. You know what I mean?
Okay.
So it's.
Did Carmen ever mention anything about hooking it up for somebody else or anything like that?
No, like I said, like she was just. I met her twice. You know what I mean?
Yeah, and I figured it was a long shot twice. You met her a year ago. I knew it was going to be a bit of a stretch for you to remember. But anything else you can think of or anything else you can remember?
No.
Okay. As you think about it, if you do think of something, let one of the COs know or one of the investigators here at the jail know. They'll reach back out to us if you think of anything else you want to talk to us about or anything like that. Okay. Any other questions or anything like that for us? Okay.
Thanks.
Anyway, then. All right. We'll go grab the CO and let them know you're ready. Okay.
Mr. Bloodworth, the state's next witness, please.
Your Honor, the state calls Molly Crosswait.
Miss, if you would step in front of Brittany, we'll get you sworn in, please.
She's agreeing.
Can you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Please have a seat.
Please proceed.
Thank you, Your Honor. Good morning, ma'am. What, ma'am, is your name?
My name is Molly Crosswait.
And is the last name spelled Crosswhit?
Yes,
Do you know who Kouri Richins is?
not personally, but through this trial, yes,
Okay. Did you purchase a home from Kouri Richins?
I did.
When did you purchase that home?
It was January 26, 2022 is when we closed on that property.
Scott, can I get 8-12, please? Your Honor, permission to publish. This has been admitted already.
It's up.
No objection.
Ms. Crosswhite, do you recognize that house?
I do,
Is that the home that you purchased from Kouri Richins?
yes.
Did you ever move into that home?
No,
Did you rent that home?
I did.
When did your renters occupy that home?
They moved into the property March 30th of that year. Their lease began March 1st, but they did not move here till the 30th.
You said you closed on that home, I'm sorry, the 26th or 27th?
I think it was January 26th.
January 26th, 2022.
Yes,
And was that home occupied between the date of the closing and the end of March when your renters moved in?
it was not.
Were the locks on that home the same as they were on January 26th when you closed to the time your renters moved in?
They were the same.
And did Kouri Richins rehab that home for you?
Prior to us purchasing it, it's our understanding she had done a renovation.
And Did she have the keys to that home throughout that renovation process?
I would assume so.
Am I right then, as far as you know, that home was unoccupied between January the 26th, 2022 and the end of March 2022?
That's correct.
Thank you, ma'am. That's all the questions I have.
Ms. Lewis.
Good morning.
Good morning.
So, oh, excuse me, can I grab some water? So before you closed on the home, you entered into a real estate purchase agreement,
That's right.
right? And can you pull up Defense Exhibit 1024, Katie? Thanks, Alex. Ms. Crosswait, do you recognize that as the real estate purchase contract that you entered into?
Yes.
And do you know the date that you entered into that?
Looks like it was January 14th, 2022.
Your Honor, we'd move to admit Defense Exhibit 1024.
No objection.
Defense 1024 is admitted. Would you like to publish?
Sure.
Okay.
And then, Ms. Crosswhite, you closed on the home January 26th, was your testimony.
Yes.
Between January 14th and January 26th, did you do a walkthrough of the home?
Yes.
And what was in the home at the time that you did the walkthrough?
The home had been staged when they were marketing it for sale. So at that time, there was furniture in it. I think by the time we did our final walkthrough, which was a couple of days before we closed, all of the furniture had been removed from the
Right.
property.
Was there anything else in the home once the furniture was removed, such as boxes?
Not that I recall. I don't remember exactly what was still there, but I do know that we had wanted the home to be fully vacated and all of the debris, and there was some garbage and things on the premises, like old cars even, that we had asked to have removed.
So do you recall if there were any boxes or cups or any items left in the closet of the home?
I don't remember.
Had there been, would you have asked that that be removed when you did the walkthrough a couple of days before closing?
I think that if it was something significant that we would really notice as a bunch of garbage or something that was going to be troublesome for us to remove from the property, we would have asked for it to be removed. Like a small item like a cup, I can't say would have stood out.
All right, that's fair. Now, you said the renters, their lease began March 1st. They didn't move in until the end of March. But was there work being done on the home during the time you closed and the time the renters moved in?
There was.
And particularly, was there work being done throughout February of 2022?
Yes, I think I provided a list of dates that was on record with our contractor. I think there was maybe 7 different days in February when there were contractors working on the property.
Okay. Would some of those dates have been February 10th, 11th,
Yes, that sounds familiar.
12th, 13th, and 14th? Does that sound familiar?
Yes.
All right. And you think there were additional dates other than those 5?
I think there was 2 more dates the following week, maybe that the 19th and 20th, if that's, I'd have to look back at the records, but according to my contractor's records, there was 2 more dates in addition to those 5 that you named.
Okay. And when they were working on the house, do you know if they were there all day, most of the day?
I don't know how long they were there. We were having things like insulation added into the attic and mortar added to the pot rock because there was animals coming into the home and things like that. We needed to get it ready for the tenants.
Okay. When you closed on the home, did you take possession of the keys?
I think that the key that was provided for us to access the home when we toured the property and made our offer remained at the property. I can't remember if it was hidden underneath, like somewhere at the front door. And we left that same key there for our contractors to use while they were working on the property.
All right. Did they keep the home locked?
I don't know.
Did you ask that they kept the home locked?
I would expect for them to. I mean, that's the point of a key.
Right. And the key wasn't in a visible spot, true?
No, I remember us having it hidden somewhere near the front door, maybe under a pot or under where anybody would think to hide a key. Probably not a great place to hide a key.
And it was your expectation the home would be locked throughout that time?
Yes.
Is that fair? All right. After you closed on the home, did you have any further conversations with Ms. Richins?
No, I never had any conversations with her directly. She was represented by another real estate agent.
Did you have conversations after you closed on the home with that agent?
I doubt it. I can't remember, but I would be surprised if I did.
Would you have would you have told them the work that was going on in the home and who was in and out of the home? Would they have been aware of that?
I think that prior to us closing on the property, we definitely communicated our plans. It was part of our negotiations because we discovered quite a bit of work needed to be done in addition to the renovation that Ms. Richins had done. So I definitely had communicated, hey, we're not going to be able to rent this out the way that it is. We need, I think it was a $10,000 credit so that we were able to, complete the renovations in a way to make the home habitable.
Okay. And is there any reason they would have known the Ms. Richins or her agent that you were talking to when, in fact, renters were moving into the home?
I don't know. I don't know if we shared that or not. I know that we definitely communicated we could not rent it out right away.
Okay.
And we had to take care of quite a bit before we felt comfortable having people move in.
All right. About one moment. Do you recall Ms. Crosswait being interviewed by Mr. Bertram, in this case, the defense investigator?
Yes.
And do you recall telling him that when you took possession of the house, there was nothing in the house at that time?
Yes.
All right. And do you recall telling him at that time that you actually turned the key over to the contractors?
I don't remember. I never met the contractors on site, so I'm sure I did communicate to them where the key could be found on the property.
All right. Nothing further.
No, Your Honor.
You may step down. Is this witness released, counsel?
Yes, Your Honor.
Yes.
Okay, you're free to go. Thank you. Mr. Bloodworth. Oh, Ms. Sherbanek. Wow, I shouldn't make assumptions. I apologize.
Allison Wright, Your Honor.
Let's do it. Miss, if you'd step in front of Brittany, we'll get you sworn in right here, please.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the things and penalties of perjury? Thank you. Please have a seat.
Good morning.
Good morning.
If you could please state your name and spell your last name.
Allison Wright, Wright.
Ma'am, where do you work?
C&E Stonemasonry.
How long have you worked there?
Since established in 2010.
Did you know Eric Richins?
Yes.
How did you know him?
I first met him in junior high. He was a friend of my sister's. They were both in high school. He spent time at our house, and eventually we ended up in high school at the same time.
And is your husband was his business partner? Is that
Yes.
correct? Did you know Kouri Richins?
Yes.
How did you know Kouri Richins?
When I met her when she was dating Eric.
I want to talk with you about a couple of handwriting items before I ask you a few other questions. That's State's Exhibit 8-49 for the record. Sorry, I've got too many things on my podium here. All right. So I'm going to hand you this booklet.
Okay.
Okay. If you could turn to tab 4 for me. Do you recognize those items in tab 4?
Yes.
Is it, and if it's multiple pages, you can look through all the pages. Is it just the one page?
There's multiple pages.
Okay. And the first page is the one that you recognize. Is that right?
Correct.
And go ahead and turn to tab 12 for me.
Okay.
And do you recognize those items?
Yes.
What are in tab 4 and in tab 12? What are those items?
They are returned checks from C&E Stonemasonry's banking account.
And are those checks that you gathered and gave to Katie Richins Benson?
Correct.
And you gathered those from C&E's accounting books and things like that, their bank records?
Correct. The check on tab 4 was collected on an online banking, and the other ones were printed checks from our files.
What do you do for C&E?
Admin and bookkeeping.
Okay. So I want to switch gears. I want to turn your attention to February of 2019. Do you recall that time frame?
Yes.
Was there a time in February of 2019 that you took a vacation with Eric Richins and Kouri Richins and your families?
Yes. No, just the adults.
Just the adults. Okay. No kids were there. And do you remember a conversation during that trip with Kouri Richins that stood out to you?
Yes.
Go ahead and describe for the jury what you remember about that conversation.
On our vacation, Kouri and I ended up alone for a moment and just talking about our families, life, kids.
Your Honor, objection, can you approach?
Yes. Please stand up and stretch your legs. We'll invite you out of court. Please rise for the jury. Please have a seat. We're still on the record. Ms. Sherbanek, if you would just ask me several questions, we'll see where this goes.
Certainly. And so now that we're outside the presence of the jury, we're just going to get a preview of how you would answer the question that I just asked you. So describing what you remember from that conversation with Kouri Richins from the vacation.
while we were sitting there, we were discussing life, and Kouri then explained how things weren't super great in her marriage, how she felt trapped. She explained to me that there was a prenuptial agreement that was put in place, and I had never heard of that. She continued to say how I think the trap was mostly due to financial, is Eric would, because of the terms of the financial agreement, Eric would end up benefiting financially and continue to live as they currently were, where she would be in a different circumstance. She explained how she feared that the kids would be drawn to Eric's life and felt like she was unhappy in there, but feared what it would look like if she ended the marriage.
And is it okay if I ask a follow-up question?
Of course.
Did that conversation kind of give you context or inform you about Kouri, kind of what she was doing with her business at that time?
Yeah, things started to make sense. Like I was impressed that she went and got a master's degree. Kouri's motivated, hardworking, and I always admired that. And she was very motivated, it felt like, to become financially independent.
Your Honor, this conversation, can we get a foundation of exactly when in 2019 this conversation took place? Sometime in that year?
Mid-February. Okay. I think the trip started on the 17th, and
Yeah.
I'm not sure what day.
Do you want to have this discussion with the witness
I
present?
do, outside that, if she could step down and step out.
Do you want any more of her recollection before we have the conversation?
No.
Okay. Do you mind just waiting out in the lobby for us for a
Yes.
minute? Thank you.
Your Honor, may it please the court. According to Mrs. Wright, this conversation took place in February of 2019. 3 years prior, more than 3 years prior to Mr. Richins' death. In the interim, in between 2019 and 2022, the Richins attended marriage counseling and worked on their marriage, and a bunch of water under the bridge. This, to allow a conversation on a vacation in a situation where two women are just chatting about the condition of their marriage, 3 years, there's certainly no allegation here that Kouri Richins was planning to murder her husband 3 years in advance. Outrageously prejudicial due to the temporal distance in the statement that is being made. No relevance because it's 3 years prior.
Why isn't it relevant to show that Ms. Richins was aware of the outcome financially that would flow to her from a divorce based upon the prenuptial agreement?
She's aware of that when she signs the prenuptial agreement. They've entered the agreement that she signed.
This is, well, I mean, I think you've answered my question. It is relevant to show she's aware of it.
No, sir. The conversation in 2019 certainly isn't relevant. They have introduced a prenuptial agreement that she signed. It's clear that she knew.
I apologize for interrupting you. It's not clear because it doesn't, I have no evidence that she read it. I don't have any evidence that she understood it. Here, I have a witness saying she understood it, was aware of it, was fearful of it, was taking steps to mitigate.
Okay. If that's going to come in over my objection, certainly respect your ruling. We've made our record, but I would ask that all the rest of that conversation be stricken as too far away, about being trapped in her marriage, about being unhappy. Everything about that is utterly irrelevant and outrageously prejudicial. And we would ask that it be stricken and only be allowed to say that she discussed her prenuptial agreement and that's it. And we also would like a continuing objection to any questions of this witness about any conversation in 2019. We respect your ruling on that.
Okay, so defendant's objection to this series of questions of Ms. Wright is overruled. The testimony that was put on the record through the voir dire requested by defendant is relevant because it shows defendant's genuine subjective awareness of what she believed were the financial consequences that would flow to her if she and her husband divorced. It provides additional probative value because it shows that she was concerned about having less money than her husband if they divorced by virtue of the prenuptial agreement. She was taking steps to mitigate that potential, potential financial effects. She was concerned about how her children might associate more with her husband by virtue of the lifestyle that he would be able to maintain in a post-divorce financial environment. That is all probative to the issues in this case, and it is not substantially outweighed by the danger of unfair prejudice.
Your Honor, can I also get a ruling just to avoid having to take another break when the jury comes back? Obviously, I have a right to go into her credibility and bias at this point, no matter what's being asked on direct, correct?
That's a very broad statement. You can certainly go into potential sources of bias.
Thank you. That's all I need.
Okay. Okay. Folks, let's take a 10-minute break. We'll come back at 10 of 12. Thank you. No one is allowed to speak to Ms. Wright during this break. Please give her some space. Thank you. Court's in recess.
All right.
Burmester ready for the jury?
Yes, sir.
Ms. Sherbanek?
Yes, Your Honor.
Okay. Yeah. They can come in when they're ready. You have a glass of water?
Yeah, thank you.
Okay.
All rise, jury.
Please have a seat as you come in. All right, please have a seat. Ms. Sherbanek, please proceed.
So, Ms. Wright, before we took our break, I had asked you about a conversation you had with Kouri Richins on a vacation you took. When did that vacation take place?
February of 2019.
And what was that conversation? Describe for the jury what happened during that conversation.
Kouri and I were finally in a position where our husbands were no longer with us. We were just discussing life. We both have kids, our marriages, and Kouri opened up and shared that things were difficult at home. And a word I remember is that she felt trapped. At this time, I learned that their marriage had a prenuptial agreement, and she explained that she felt like she was frustrated in the relationship, but also it would be difficult to leave. Eric would end up financially secure, and her the opposite. She feared what would happen in divorce. She mentioned that maybe the kids would prefer him with the lifestyle that they had, four-wheelers and toys and opportunities, where she would have less. She feared how she would be represented by him in the community. I felt for her. It was a hard conversation. I knew that things had been hard since their youngest child was born, and I was tender towards her current circumstance.
Thank you. And did that conversation give you any context to what was happening in terms of Kouri's business at that time?
Yeah, Kouri is super ambitious. She went back to school and got a master's degree. I was impressed. I had young kids. I wasn't sure I could do that. She then went and got a real estate license and was trying to build that business. That conversation kept playing in my mind as I think this is a way to become financially independent and secure.
Thank you. Those are all my questions for you. The defense may have some. Thanks.
Thank you.
May it please the court. Good morning.
Good morning.
This conversation you're talking about happened in Hawaii, didn't it?
No.
Where was it?
Costa Rica.
I'm sorry, Costa Rica. And the reason you all were talking about her marriage, there was a reason she was upset in her marriage at that time, wasn't there?
Not that I know.
Think hard.
She was upset. What I understood from the conversation is things were frustrating at home.
And that's because she believed he was having an affair with a coworker. Is that right?
Overruled.
Is that right?
She and I never discussed her thinking about an affair.
Is that the context of the conversation you were having that day, that she believed he was having an affair with a coworker? And that's why she was upset with her marriage and talking about divorce.
I don't recall that.
Were you aware of it at that time, that there was an affair going on between Eric and a coworker?
I don't recall that conversation versus when I found out.
When did you find out?
Or wait, I'm sorry, will you repeat that question?
When did you find out that Eric was having an affair with a woman that worked with him?
These are facts, not in evidence. Assumes facts, not in evidence.
Foundation. You got to lay foundation for this. I'm not sure this witness knows anything about it. Why don't you ask her?
You just testified that when you found out, you weren't sure if it was during this conversation. So when did you find
No.
out?
That's not accurate. You have to ask it open-ended.
Okay. When did you find out? Was it any time near this conversation?
Will you repeat that question with more detail?
When did you find out that Eric was supposedly having an affair with another woman in context to this conversation? Before, after, during?
I'm having a difficult time understanding because help me understand affair. Because like, I think there was a friendship with a lady, but I don't know exactly what was going on.
Understood. That's fair. So let me rephrase it. Did you become aware that Eric had intimate feelings towards a woman that he was working with?
Your Honor, assumes facts, not in evidence.
She's
Argument in a
asking
question.
whether this person ever became aware of it. Overruled. It's a yes or no question. Ms. Wright, could we start there?
Can you repeat the question?
Did you become aware that Eric, at around this time, 2019, had intimate feelings towards a woman, that another woman that he worked with, that was causing problems in their marriage?
I don't remember when I became aware of it.
Ballpark.
I'm sorry. I think I'd heard of it like twice, and I don't remember. I'm sorry, I don't remember.
When you were having this conversation with Kouri, did you know at that time?
I don't believe I did.
All right, these vacations, you had vacations with Eric and Kouri on more than one occasion, didn't you guys?
Yes.
And then at some point, those totally stopped, didn't they?
Yes.
And what happened that made you guys stop going on vacations together?
COVID was the next year.
Besides COVID.
Our family life was busy.
In fact, didn't Cody and Eric have a big falling out? Your husband is Cody Wright, correct?
My husband is Cody.
And how does Cody Wright know Eric?
We were friends in high school. They went on to work together, broke off and started a business together, and maintained their friendship.
So they were business partners.
Correct.
And they both owned C&E Stonemasonry together, right?
Correct.
And at some point, your families quit hanging out. Personally.
We continue to go to birthday parties and like that kind of an event. No longer vacations. I think we had a vacation planned in 2020 that got canceled due to COVID is the one that I recall.
In fact, didn't Eric and Cody have a falling out over Cody calling the police on Eric?
Cody didn't call the police on Eric.
Did Cody provide testimony against Eric with relation to an investigation against Eric for
Objection,
violating
Your Honor.
hunting laws?
Lack of foundation.
Well, this is a different question. Ask her if she's aware.
Are you aware that Cody provided information to law enforcement against Eric for a violation of hunting laws. Okay.
Yes.
And Eric and him, as I would say, fell out over that. I don't know another word. Had a disagreement about that.
Yes, temporarily.
And you guys never vacationed together again after that, did you?
No.
All right. Now you said that you did the payroll and the bookkeeping at C&E, is that right?
We have a payroll service company.
Oh, sorry, sure. Okay, but you do the bookkeeping.
Yes.
So you know how much money is coming into that company, right?
Correct.
And you know how much money is going out, right?
Yes.
And do you and your husband have joint, do you share your marital money, or does he keep his business money separate?
We share our marital money.
Pause for 1 second, Ms. Nestor. Go ahead, Ms. Sherman.
Outside the scope, correct?
Sustained.
All right. Setting aside your personal financial affairs, you're very aware of C&E's financial affairs, correct? Because you do the bookkeeping.
Correct.
All right. And
Objection, Your Honor, this is still outside the scope.
no, it's not.
Yeah, please approach. I'm not sure where you're headed here. Ms. Nestor. Your next question, please, Ms. Nestor.
Since Eric's death, you and your family have grown pretty close to the Richins family. Is that fair?
Objection, Your Honor.
Goes to
Outside the
bias.
scope.
Goes to bias.
Overruled. If you would please restate the question.
Since Eric's death, you and Cody have become very close to the Richins family. Is that fair?
I would say the relationship didn't change.
So you were very close to them before.
Yes.
And it's true that since Eric's death, your husband has even accompanied them to court hearings and sat beside them. Is that right?
Yes.
Have you?
Yes.
And I think everything else is going to be when we recall. Ma'am, we're going to recall you later. We would ask that you're not releasing your subpoena, and the judge will instruct you about that. That's all we have at this time, Your Honor.
Okay. Anything within the scope of cross, Ms. Sherman?
I could just have a minute.
Of course.
No, Your Honor.
Okay. Ms. Wright, you're free to go today. You're still subject to the subpoena that you were served with. You may be called back. Between now and then, please do not speak to anybody about your testimony, including your husband. Okay? And please don't watch any coverage of this case. Don't read, listen, watch anything about it. Do you agree to do those things?
Yes.
Very good. You're free to go. Thank you for your time.
Thank you.
Good time for a lunch break, counsel? Or do we have another short witness you want to get on and off?
Your Honor, we can break. I understand there's some legal issues to address too, so.
Understood. Okay. Any objection to a lunch break,
No, sir.
counsel? All right.
No, sir.
Please rise for the jury. Folks, quick reminder, you know what I'm going to say. Please don't discuss the case. Don't read, watch, or listen to anything about it. Please don't do any research. Enjoy your lunch. 12:40, counsel, is that reasonable?
Yes, sir.
Yes, sir.
Okay, 12:40. Thank you. Have a seat. Thank you. We're on the record. Mr. Blood.
Your Honor, we're gonna quickly next call Detective O'Driscoll just for a phone download. He'll have perhaps more time later.
Okay.
But then it's Mr. Coachapimos, and I understand the defense has some objections related to Mr. Coachapimos.
Mr. Ramos, tell me more.
Thank you, Judge. I figured we'd do this just outside, that way we can speed things along. We've been provided with some exhibits that appear to rely, and correct me if I'm wrong, on some CDR data, call detail records, from Verizon and T-Mobile, I believe, and AT&T. Those items, we were not provided notice of their use under 901.11. And so we would just make an objection under that.
Forgive me. They were provided some reasonable time after being received by the state.
Yeah, no, the information was provided to us. We've had that for a while. Just notice of their use under that business record exception.
Can you give me that citation one more time?
Yeah. Apologies. Rule 902.11, I believe is what we would be coming into, in through. And specifically, I'm referring to the written notice.
Why isn't inclusion of these records on the state's exhibit list fair notice under 902.11?
Just based on the case law, Judge, I could give you a citation. I have two cases I think are fairly on point. 32P3D 976, State v. Webster.
What's the other one?
And then 322 P3D 624, State v. Pereira. We just bring this up, Judge, now. We could have a ruling after lunch is fine. And that would be our only objection.
Okay.
Thank you, Judge.
Mr. Bloodworth, I made an assumption there, if you could just confirm it for me. These call detail records were in fact included among the state's proposed exhibits on its exhibit list?
Yes, sir.
Okay. Anything further on this, sir?
Yeah, right, Your Honor. Just to clarify that, they've been disclosed and the disclosure included the certification from whoever returned the subpoena.
Right. The declaration. I understand your point to be slightly different than the self-authenticating piece. Got it?
Correct.
Okay. Pause there for a minute. I'll take a look at those two cases, Mr. Ramos. We can pick this up at 1240. After Ms. Crosswait testified and after we took that break, one of the jurors passed out the following note. I'll read it. I don't think this is an issue, but just letting you know. Quote, Judge, I have met witness Molly Crosswait professionally. She has done one transaction for a home where I work. Any concerns, Mr. Bloodworth?
No, Your Honor.
My to-do list.
Sure.
Either following lunch or at the end of the day, may we address the motion for mistrial that you made at sidebar following the mention of jail calls by Ms. Gibson?
Yes, sir, I'm prepared whenever you are.
All
Just
right.
let me know.
Let's do that after lunch as well.
Okay.
Thank you. We will be in recess until 12:40. Thank you.